So I'm just going to speak for a bit about free speech fundamentals. I want to do it on two sides. One is about the expressive side, and the other is the information access side. So I'm going to cover a lot of territory, but just try to impart a few basic ideas, and then I'm happy to talk more about what you are interested in. So first, on the expressive side, the ability to express oneself, to speak, organize, and demonstrate. I don't think you'll find very much inspiration in our early history. In fact, more those will be points of contrast, lessons in terms of what you do not want to do, how we do not want to build society and communication. So a couple hundred years ago, live issues were such along these lines. Well, is it okay to criminally punish for truthful criticism of the government? Or is your right really just restricted to not having to check with government first before you start communicating through a prior restraint system? So that's a level at which the debate was taking place, and we're way far beyond that. So it wasn't really until generations afterward and through persistent protest movements, organized demonstrations, that people in general, lawyers and judges more particularly, started to grapple with what ought to be the fundamental principles for designing free speech. So that really didn't happen until the 1950s and 60s. And just to make a very, very long story short, some key distinctions were made. So regulation of communication in terms of time, place, and manner, that's generally going to be acceptable. What's generally not going to be acceptable is government regulation that tries to choose sides in an ongoing debate, or that tries to identify a certain kind of content of messages for prescription. So these are crude generalizations, but they hold pretty well. So there's still some room for intervention and resistance if you don't like the way in which the time, place, and manner of your communication is being regulated. It's still possible to get judicial intervention on those grounds. So if government tries to delay your speech too long, 30 days is probably too long. If you want to do a street march, wars get fought and won. Not all wars, some are 30 years wars, but some of wars are much more rapid than that. And so to be able to communicate in a timely and peaceful fashion, you need to be able to do so more rapidly than 30 days. But it's also true that these restrictions on time, place, and manner are going to influence the kind of message that you can communicate. That's just the manner of your speech and the content of your speech is obviously intertwined. So what constitutional law is doing in this field is really making a kind of modest intervention to crude tactics to try to eliminate certain messages or push them down. And even then, there are a wide variety of exceptions, and that's a good thing. So fraud, that's a content-based intervention. In fact, it's a kind of mind control. So you need to be thinking one thing and saying something else for your fraudulent design, and there's no limitation on government's ability to go after that, and that's a good thing. Okay, so that's a basic kind of division to keep in mind. Is government trying to channel and regulate the time, place, and manner, or is government trying to overtly suppress one kind of message in an ongoing debate? One note here, though, it turns out that a particularly powerful form of communication is to break the formal law with no constitutional claim available to you. And as a lawyer, maybe it's awkward to recognize that, but I'm a professor too, probably more so at this point. And so what the ability to break the law does with no constitutional complaint is to be able to carry out a form of civil disobedience. And I'm not encouraging you or inciting you to do any such thing at the moment, but I want you to note that your ability to communicate effectively, to drive a message home, to do so with intensity in a way that's credible to an audience usually does not depend on your ability to waltz into court and file an effective complaint. On the other hand, there are many people who are just extra vulnerable if they are engaged in even technical law violations. And so for those students and others who are particularly vulnerable to the force of formal law, then those kinds of civil disobedience exercises, the stakes are just higher. So you want to pay attention to that. All right, so now I'll just spend a couple more minutes talking a bit about the access to information side. So there are plenty of ways in which to express yourself, show your identity, connect with others, tweet and retweet. That's also often a really superficial exercise. So that can amp up the volume on observations that other people have dug up. So what about digging out the information on which the volume might be increased? So in that area, we don't do so well in terms of formal law. So we have a very weak Freedom of Information Act. We have versions of that at the state and local levels, but that's a weak claim to get certain recorded information. So, and the First Amendment, as understood by the courts, almost never allows you access to information about government operations at all. Now, when government is really coming at you or you're interfacing with government officials, then you have a sense of what they're doing, but not all the time. And much of what government does is really out of your view. So what our system relies on for delivering information about government operations is really something very different. It's not formal legal claims. They tend to be informal relationships between what we used to call journalists. Maybe journalists is still the right term, but some group of people who are outside the government who have contacts with people inside the government to deliver information about how operations are going. Now, once the information is out in public, courts have been quite protective of those who continue to disseminate the information. So if you're a private party, you're not a government official, you didn't sign a non-disclosure agreement, you aren't, some rat fink like Snowden, you didn't do that, right? So you're an outsider. I'm using provocative terms. You can do with them what you will. So in any event, if you're an outsider and you receive the information, continuing to disseminate it, you're highly likely to be protected. But insiders are not protected by these formal laws. There are some whistleblower laws. They tend to be pretty weak as well. So what that means is there's a lot of incentive and pressure on government officials to bottle up the information at the front end, because if it gets out, the best they can do is maybe fire people. And so that's the system we're running now, is informal relationships are often the best resources for getting actual information, which you out there can retweet. But that also means that the arbiters of what ought to be disclosed are not always going to be operating in the public interest. That's an ongoing dilemma that we face. Okay, so those are some just basic lines of division, conceptual and practical, that we see in law over the last 200 years. So that's pretty good for 10 minutes. Okay, thanks. That's all. That's it for now.